the implications in the life sciences world. The life sciences world, the FDA-regulated world, is lives and dies off of patents. Now, if you take Judge Rakoff's decision, the Heppner decision, at face value, what we're saying is that a disclosure made to an AI does not get attorney-client privilege. Fair enough. The next step that goes along with it is it does not get confidentiality. Interesting. If it does not get those confidentiality protections, what you now have is a disclosure under trade secrets and patent rules. What that means is that under trade secrets, once something is disclosed, if it's publicly disclosed, you don't have any protections. Imagine the Coca-Cola formula that gets disclosed on an AI. You now have a scenario where that becomes problematic because something you may have protected for 100 years is suddenly disclosable. We'll take the next step forward. What if it's not the Coca-Cola formula, it's the formula for Ozempic? So it is going to be patented. But before you've patented everything, someone else, think of a clinical trial site, uses an AI that you as the pharmaceutical company did not vet. And it's happening every single day. I know of companies doing this stuff. So you now have a scenario where these pharma companies have vendors, i.e. doctors' offices, who are doing the clinical trials. They're using unapproved AI. It gets your technology gets disclosed. You as the pharma company don't know about it, so you don't file any intellectual property in those scenarios. Your next step is that 5 years down the line, if I was a if I was a rival pharmaceutical company that wanted to make your product, I would sue you and say, I want to use your product. You would say, no, I have a patent on this thing. And I would say, you had a year to get a patent on your intellectual property. There was a disclosure made, which you may or may not have known about. But that disclosure means that you didn't get patent protection in time, which means that the patent you have is itself invalid.
Hi, and welcome to Main Street AI, the podcast where traditional businesses are quietly revolutionizing their operations with artificial intelligence and winning. In this podcast, I sit down with industry leaders from law firms and professional services and other Main Street businesses to explore their AI journey. We dive into the opportunities they see, the challenges they're navigating, and the real impact of AI on their industries. Whether you're AI curious or ready to implement, this show brings you insights from leaders who are actually using this technology to serve customers better, empower employees, and drive profitable growth. Darshan Kulkarni is a pharmacist, attorney, and founder of Kulkarni Law Firm, where he represents life science companies and FDA-regulated businesses across regulatory law, compliance, and intellectual property. He holds a Doctor of Pharmacy degree and a Master's in Quality Assurance and Regulatory Affairs, has chaired 2 American Bar Association interest groups, authored chapters in dozens of legal texts, teaches food and drug law at Drexel University, and has lectured at Cornell, UPenn, and UCLA. This conversation took a different turn than most of our episodes, as Darshan brought a deeply layered perspective on the legal implications of AI that most people in and outside the profession haven't thought through yet. We cover the Heppner decision and a lesser-known ruling that came out the same day with a completely different conclusion, the potentially devastating consequences for pharmaceutical patents when clinical trial sites used unapproved AI tools, and why the existing legal framework already applies to AI in ways most people are overlooking entirely. Let's dive in. Hi, welcome back to the Main Street AI podcast. This is Stephen Whittier with Security Coach IO, and today I'm joined by Darshan Kulkarni of Kulkarni Law Firm. Darshan, thanks for joining.
Thank you for having me.
Excellent. Please go ahead and just give us a quick overview and background on what you do.
So my background is I have a doctorate in pharmacy. I'm an attorney. I have a master's in quality assurance regulatory affairs. I work with life sciences companies and their service providers, and also with FDA-regulated companies overall. So that includes FDA regulatory law, but also compliance, and tying that into like the med spa world and the compounding pharmacy world, all those guys. I was chair of the American Bar Association's Life Sciences Interest Group. and their fraud and abuse interest group in the past. If you can see the books behind me, I don't think the angle catches it, but a few of them you can see. I've written anywhere from 1 through 6 chapters in every one of the books behind me on a variety of life sciences related topics. I teach food and drug law at Drexel University, but I've lectured in a variety of universities, including this year it's been like Cornell and UPenn and USC, and a few others. UCLA and a few others. And I do my own podcast called Darshan Talks, which is why you see the thing behind me, the giant microphone in my face. And it's an absolute pleasure to be here. So thank you for having me.
Excellent. Yeah, it's a pretty incredible resume you have. And normally I ask some follow-up questions on just your area specialty, but based on our quick chat right before we went live, I just want to dive into the AI question, the technology, because you have a extremely nuanced and robust perspective on that. So please talk to us a little bit about what you're seeing with things trending, the implications in particular, some of the things you were mentioning. I just wanted to jump on live so we could dig into it.
Sure. I mean, maybe we can start with some of the So, just to be clear, to a man with a hammer, everything looks like a nail. So to me, I'm very much a man with a hammer. So in this scenario, I find myself looking at the intersection of law and health and what are the implications thereof. Obviously, there are independent legal implications, and then there are independent healthcare implications, and we'll talk a little bit about each of them. The big pieces I think we're all struggling with overall is number one, everyone starts off with, we need laws for AI, and without laws for AI, we have no, it's a free-for-all. And I think we need to stop saying that, because that's just inaccurate. All the laws of the past do apply to AI. So to the extent they're applicable, do not expect those laws not to apply. What we do not have is a single unified AI law, which the government's been working on. But to be fair, they've been working on a similar privacy law for at least the last 10 to 15 years. So I'm not holding my breath for that. I would be pleasantly surprised if it came out. But think about, for example, the implications on privacy. Simple things like, there are no laws that apply to AI. Well, privacy laws apply. And when you talk about privacy laws, a simple thing like, if you look at California's CCPA, or if you look at the EU's GDPR, they both have the right to be forgotten. Well, if your data was used in AI, how do you pull out just that data? And there's no clear way on how to do that. So that'd be the first sort of misstatement that I would like to pull out. The second misstatement is the fact that we don't really have any sense of control around AI. The AI is independent in many ways. And that's the reason why, for those people who are listening, I live in Pennsylvania. The governor, Josh Shapiro, went out there and he filed a lawsuit against a company called Characters.ai because they had an AI that held itself out as a medical doctor. And from what I understand, I haven't read the specific facts of the case, but from what I understand, it was cajoled into making that declaration. But if it was cajoled, and even then, if it said that, it is still a problem. So your AI does not become licensed purely because it exists, and does not even become licensed because it may even have access to information. And that's one of the key things that's happening. And what we're seeing overall is this push. I remember in the healthcare world, we always had Dr. Google. So if you're sick, you know what, go ask Dr. Google before you go see your real doctor. And we all did that. Well, Dr. Google at some point became Dr. ChatGPT. And people took that a little too seriously. And I remember going back, I want to say 2 years, we heard about the first case of suicide where a young kid listened to AI, which effectively he got gaslit and he committed suicide. I believe that recently happened again last week is another one I heard. So it's not the problem is not access to information. It's that the information is not vetted and the tool is not ready. People will try to put skins on these tools, like the characters.ai, and then sort of it'll put itself out as a qualified professional when it's not. In fact, it's so much not the case that I think this is my recollection. I can't remember whether it's it's so much not the case that New York, for example, has come out and said that we want a law saying that AI cannot hold itself out as a lawyer or as a physician or the like a professional. Multiple AI vendors have come out there, and I can't remember whether it's state-specific or federally, but they want a limit on how much the lawsuits can be for. So I believe they were looking at a $1 billion limit, which raises concerns in two different ways for me. The first type of concern it raises is that, well, if you think that, and I believe Sam Altman came out there and said that, oh, you know what, maybe the way people are using it, there should be a attorney-client privilege or a doctor-patient privilege. So if you want that privilege, the responsibility goes with it. So how do you cap that responsibility while asking for the privilege at the same time? The second thing, go ahead. And the second thing that goes along with that same statement is that $1 billion limit tells me that the damage it's causing is above $1 billion. Mm-hmm. And you want to cap that. And that to me is concerning. Yeah, I've been sort of doing a soliloquy. So if you want to ask questions.
This is fascinating. But one of the things I was thinking along the line, you said a key word there with the Dr. AI, which was it was cajoled. So this is where from the AI side, right, we would hope that any of the owners of these companies, these LLM companies, are going to be very concerned with safeguards. But at the same time, we're always kind of looking retroactively. How do you foresee every possible way that the AI could be cajoled to something like that and then be held liable for it? For instance, you might not ever, from their standpoint, you might not ever know that somebody would potentially cajole your AI application into actually declaring itself a medical doctor, only to then be held liable for it. I want to get your thoughts on that.
So your position, I just want to make sure I understand what you're saying. You're saying that if you are an AI maker, for lack of a better term, mm-hmm. Your AI is being misused to give answers that it may not have necessarily wanted to, despite the metes and bounds you've put into the system.
Right. You might not ever be able to foresee, in other words, all the way that it could be cajoled until somebody does it. And then you go, oh, so now we have to put in a safeguard for that. But it wouldn't have occurred to us because we couldn't know every possible variable and permutation to account for until it happens. I guess that's one of the big challenges, right?
Well, I think at this point, we can assume that most AIs are going to be cajoled, mostly because people just like to do that.
Of course.
So I think you have to start with that assumption. There is a continuing problem. And I can't remember if this was like a Wendy's menu or like a McDonald's menu. I forget the context. But there was someone who literally went to one of the big like ordering systems outside of Wendy's or McDonald's or something, and it got it to do all. They were using AI there to create like the human experience, and they got it to start doing things that were outside the ordering experience because you could. So I would tell you that you should not be surprised that people are going to try to cajole your system. The question is, what's that?
People will game the system, for sure.
People will game the system, exactly right. So the question then becomes, if people are going to game the system, do you now have to keep it within certain metes and bounds? And those are the questions people are now dealing with. For example, I work in the FDA space. And in the FDA space, The government, the FDA, has come out and said, you know what? If you stay in the wellness space, we're not going to try to regulate you in the same way as if you were like a full-blown medical device, because you know what? We think the risk is low enough. Great. I love that. That, you know what? We don't need an onerous government on top of us for basically wellness. But what if you can game that system? How do you control the uncontrollable? And as you said, you know what? Even if you knew that someone's going to game it, you still can't think of every permutation and combination. One of my favorite cases from like recently was, I think it was Claude, is my recollection. It was an app that this guy built. He put in meets and bounds into Claude. He put in rules into Claude. And then gave Claude, I want to say like 24 hours or 12 hours, something like that, and he stepped away. When he came back, Claude had deleted his entire business, including the backups. Wow. So he asked Claude, why did you do that? Like, we put in limitations so that you don't do this. And Claude, like a petulant child who had just been chastised, went, I know I've done a very bad thing. I should not have done this. And it's both cute, hilarious, and terrifying at the same moment. And that's my concern. Claude may still go, and I say Claude, but I mean obviously apply to any of the LLMs. They say certain things and do certain things despite your safeguards. What does that actually mean? And if someone gets hurt using your tool, what are the implications for that? Mm-hmm. So I think that's going to be this level above the controls you need to have. So that's going to be the one element. Then from a legal perspective, Stephen, you and I kind of briefly talked about this. Everyone's had a lot of conversations about the Heppner decision. So for those people who are not familiar with the Heppner decision, it's a live case right now in Judge Rakoff's court, and it was an individual whose attorney told them to prepare a summary. This guy wrote his summary out, then went to Claude, had it cleaned up, gave it back to his attorney. And the other side, I believe it was the government. Government said, we want access to this information. And the guy said, no. I was just preparing it for my attorney, so it should be protected. And they said, the moment you disclosed it, you lost attorney-client privilege. And the judge agreed. Everyone knows that one. That's terrifying because it has its implications, and I'll talk about those in a few seconds. However, what a lot of people don't seem to discuss is a second decision that came out the same day as Judge Rakoff's decision. And that decision involved an attorney, and I'm sure I can pull up a link to this one. It was an attorney who landed up using an AI, finding certain answers. And the other side said that the moment you use AI, it is disclosable. It's not attorney-client work product. It was publicly available. And the judge in that case said, how is that different from any of the other legal tools? Why should it not get attorney-client work product protection when these other tools do? So the question then becomes, and what everything seems to pivot on, is who is the user of the AI? And that is an interesting question because it gets to things like First Amendment rights. Because at that moment, we're saying that certain speech is more protected than other speech. And speaker-based restrictions. And I haven't thought through that analysis yet, but I just thought that that's an interesting place to be.
Absolutely.
The other element that we talked about a little bit was the implications in the life sciences world. The life sciences world, the FDA-regulated world, lives and dies off of patents. Now, if you take Judge Rakoff's decision, the Heppner decision, at face value, what we're saying is that a disclosure made to an AI does not get attorney-client privilege. Fair enough. The next step that goes along with it is it does not get confidentiality. Interesting. If it does not get those confidentiality protections, what you now have is a disclosure under trade secrets and patent rules. What that means is that under trade secrets, once something is disclosed, if it's publicly disclosed, you don't have any protections. Imagine the Coca-Cola formula that gets disclosed on an AI. You now have a scenario where that becomes problematic because something you may have protected for 100 years is suddenly disclosable. We'll take the next step forward. What if it's not the Coca-Cola formula, it's the formula for Ozempic? So it is going to be patented. But before you've patented everything, someone else, think of a clinical trial site, uses an AI that you as the pharmaceutical company did not vet. And it's happening every single day. I know of companies doing this stuff. So you now have a scenario where these pharma companies have vendors, i.e. doctors' offices, who are doing the clinical trials. They're using unapproved AI. It gets your technology gets disclosed. You as the pharma company don't know about it, so you don't file any intellectual property in those scenarios. Your next step is that 5 years down the line, if I was a if I was a rival pharmaceutical company that wanted to make your product, I would sue you and say, I want to use your product. You would say, no, I have a patent on this thing. And I would say, you had a year to get a patent on your intellectual property. There was a disclosure made, which you may or may not have known about. But that disclosure means that you didn't get patent protection in time, which means that the patent you have is itself invalid. And you could lose billions of dollars as a result of these inadvertent disclosures you knew nothing about. We're too soon to see this, but I would be surprised if in 10 years, this is not the newest problem every pharma company is facing.
Yeah, that's fascinating. Yeah, to some extent, I know it's a overused term, but whenever we have these paradigm shifts with technology, there's always a Wild West element to it. And, yeah. So it is wild, and obviously these implications are being actively discussed all over the spectrum. At the same time, we have the advantages that always come with it as well, which is, particularly as it pertains to law, we've got the efficiency, the speed. On the positive side, what are you very positive and excited about with the potential of the technology, and are you using it or engaging with it at all yourself in your practice?
So, two different answers. So, number one, I think what AI gives you is scale. What AI lets you do is, I have access to data libraries now that as a solo, I have access to data libraries that large law firms had only 2 years ago. Mm-hmm. So if I want to go, you know what, I need a clause that fits in here. I'm not going to tell you what the rest of the contract is, but these are the elements I want in there. I have a first draft that I can build on. Mm-hmm. On the other hand, before you were working off of clauses and you always tried to sort of retrofit them. These are sort of custom built clauses. So when you're working in compliance, when you're working in contract building, these become really, really important. I'm seeing tools that are being considered for compliance to keep a live sort of check on patient protections, on data that's being collected. So I work in the compliance space obviously. So what does happen is that the Department of Justice came out recently and said that if there's a problem with your AI, it is still your problem. So it doesn't endanger my job, but it does enable me to do my job better. So AI can be a really good place to get sort of red flags or yellow flags, but it should not at any point make you go, oh, I don't need to worry about it anymore, or I can depend on the AI. And I think that's the problem we seem to be facing. We seem to be depending on a really good high school intern to do your job as a lawyer. It simply is too big a chasm. And we're seeing that in the motions that are being drafted for courts, in the opinions that are being drafted by courts. So I think those are going to be fascinating and interesting as we go along. But I think the fact is that AI can give you resources you simply didn't have access to. The FDA recently came out and said, you know what, we want real-time data that's going to come from all the different doctors' offices simultaneously. I'm not sure if it'll go anywhere. This was something that was proposed right before former Commissioner McCary, head of the FDA, just left. But the fact that they would get all this data means that it has to be analyzed in close to real time. The only way to do that is using AI. So I think AI just gives you access to resources. You get to think at a more meta level. You get to see trends that you simply couldn't do using tools that we had just 3 months ago. 3 years ago. I think that'll be interesting and fun.
Yeah, absolutely. And one of the points you just made comes up on here quite a lot is when you get people in any field, really, but in this case, attorneys that really they're starting to play around with it, but they don't understand the parameters or how to properly train the AI. So they just start basically turning over work product without doing the attorney part of it, which is to review and make sure that you're doing your due diligence. Exactly. That's where we get into problems. So a lot of it comes down to knowing how to use it properly, and then adoption, which is the other thing. We had numerous conversations with firms where you'll get, say, one attorney or a managing partner or something saying, you know, I'm very AI forward, but I'm having a hard time getting others in the firm to adopt, and that's one of the challenges we deal with as well. You know, so do you have any sense? Totally hypothetical, but I love to get people's 2 cents on this. Any sense of, like, say, if we were to pan out 5 years, what you think will still look just the same in your domain versus what might look radically different as a result of this technology?
In my domain, I don't know what the world's going to look like because my domain is itself changing. The Trump administration, whether or not you like them, have completely changed how my world gets interpreted. So they talked about, for example, real-time clinical trials, which it was discussed as a concept. We did it sort of as part of COVID. However, the fact is that we've never actually faced it. So what is the role of AI? What is the role of the FDA in that world? We're still figuring that piece out. The stuff I just told you about around intellectual property, I don't even know if a lot of attorneys have thought through the implications of this. So I think it adds new challenges, new protections. I actually just had I've been invited to give a talk for pharma companies on creating new templates for their contracts in a world where AI is now a real thing, and what are the implications thereof. So I think that there are going to be massive changes, and I don't think we have any sense of what those changes look like, but I think that the risks are completely different than what they were 3 years ago. Having said that, I think one of the really cool things that I've done that I have never been able to do, like in the med spa world, I was able to use AI to get a list of all the different states and what their concerns were. So I was looking at the state attorney general's offices, the state nursing associations, the state boards of pharmacy, and the state boards of medicine, and put all of their letters relating to like compounded pharmaceuticals. There's just that project alone would have taken me 4 years to do together, and everything would have changed by the time I finished it. I was able to do that quickly. I'm able to sort of ask questions and put out information that simply didn't exist before, because it is so mind-blowing how when you have 50 state summaries for multiple topics at the same time, and you can do that in real time, it is incredibly empowering. And I think that's going to be the tools that's going to be interesting. I think that everyone's been talking about how AI should not be used. I think I either saw an ABA opinion or someone made reference to an ABA opinion saying that is it malpractice not to use tools that enable you to be the best attorney possible? And is AI one of those tools? So I don't know where that all lands out.
Yeah. Interesting. For sure. I'll pivot a little bit now, talk a little bit more about your firm. One of the questions I always like to ask is, I mean, obviously you're very specialized with what you do, but what would you say that your particular practice does extraordinarily well that sets you apart from others that might be in this same sector?
So I'd asked a recruiter, how many food and drug lawyers are there in the world, basically. And he told me that there are probably about 700 food and drug lawyers in the entire world. Out of those, I said, how many of them are really corporate lawyers who do a little bit of FDA regulatory law? And he said there are more than half of them. You probably have about 150 who aren't. He said, out of those, how many people are either working at the FDA or not? Or at the FDA or sort of are in-house. He said probably half. So I'm really dealing with maybe about 50 people to 75 people in the entire world do what I do. So I have a unique niche, which is wonderful. It's incredible. On top of that, as far as I know, I'm the only food and drug attorney who's a pharmacist, who's an attorney, who has MS and QARA, who basically has been in this world since 2005. I've been practicing for 20 something years. And I think it adds a certain level of, I'm not just telling you this information because that's what a lawyer would say. I've actually been in your shoes as a pharmacist, and here are the implications of that. The intersection of health and pharma, health and food and drug law, health and the law itself. I think I have a unique perspective, which I think is very interesting to share. Plus, I've written multiple books, and we've talked a little bit about that stuff. So I get to talk with individuals. As I was telling you about my podcast, Darshan Talks, I've done over 1,000 interviews, spoken to the best in the world at what these people do. So spoken to Rob Califf, who was ex-head of the FDA, interviewed multiple CEOs, interviewed multiple general counsels, and you get to learn from each one of them what their pain points are. And that obviously informs how you practice because you understand what your client needs. So that's what kind of makes me, I think, a resource that people can depend on.
Absolutely. In terms of thinking about growth, I always like to also dig in a little bit. So you said you've been practicing for over 20 years. And what stage of growth would you say that your practice is in right now? And do you have an objective of what you'd like to get to in the next 12 months or so?
Well, I'm a solo.
Mm-hmm.
I think I'm looking at scale now. I'm trying to understand what that scale looks like. I don't have clarity on what I'm looking for specifically. It's one of those things that I want to do the job right. And the question is, some of it is using AI, some of it is using like full-fledged attorneys from India, but they can only do certain elements that I simply, it would be a waste of using my time to doing that. So it's me providing oversight while they provide some of the rote work that they'd have to do. So again, adding scale to something. That's kind of what I'm working through right now.
And you're not looking to try and bring on others. You're just, because your brain is responsible for things that only you know. So you're just trying to basically outsource certain things that you don't need your specific knowledge base for. Yeah.
I mean, no one's saying no to growing, and I'd love to grow, but I don't have a clear enough plan yet. I haven't formulated that into how to grow that in a way that still protects the interests of my clients.
Right. If you had the ability to just wave a magic wand and fix one limit to scale or limit to growth or anything might be like holding you back from your plans, what would that be?
People who think like me. Finding people who think like me.
Right. Yeah. The classic key man challenge.
Exactly right.
Absolutely. Darshan, where I like to end the arc of these interviews, as we've talked, like it was just a fantastic probably the deepest dive we've had yet into implications of AI. We've had some good ones, but that was very interesting. And so I like to talk about the tech. We talk about business a little bit. I always like to end on the personal, the human. So I ask here now, what's your personal why, aside from wanting to be a successful lawyer and represent your clients well, of course, but what's your personal big why for what you do?
I'm a sixth generation pharmacist. My dad owned a pharmaceutical company. His dad owned a pharmaceutical company. And before that, they owned pharmacies because you didn't really have pharmaceutical companies in the same way. My family's been in the business of hopefully saving lives, going back as many generations as we can look back. This is my contribution towards making it happen. Interestingly enough, my niece is trying to get into biotech herself, so maybe that legacy continues. And I've been lucky to see not just at the macro level lives I get to affect by helping in the pharma industry, but also I've worked at multiple pharmacies, and I've had patients come up to me and go, you know what, I can't afford this drug. I have 12 drugs, I have $10. You tell me which drug I should take. And that is not a decision anyone should have to make. And I hopefully get to play a small role in making sure no one ever has to make that decision. And I'm looking forward to allowing people to live a life on their own terms. So,
yeah, very, very well said. Love it. How can people find out, best reach you, find out about your services?
So you can go to my website, www.kulkarnilawfirm.com, KULKARNI lawfirm.com. You could also just email me at darshan@kulkarnilawfirm.com. Or you can find me on LinkedIn at Darshan Kulkarni.
And also Darshan Talks. So
Darshan Talks.
For your podcast.
Thank you.
Excellent. So great stuff today. Really appreciated having you on. Thank you.
Thank you for having me.